This is an appeal on the matter of the Mayor and Burgesses of the London Borough of Tower Hamlets and various leaseholders of Brewster and Malting.
Yes, Mr. Bates.
Good morning, my lords. Well, may it please you, I appear with Miss Green for the appellant, the London Borough of Tower Hamlets, and my learned friends, Miss Gibson and Mr. Thompson, appear for the respondent leaseholders. Can I just check that everything made its way to you? A core bundle of 119 pages?
Yes. Yes.
My lord sounds rather less certain than I was hoping now.
Well, you can't expect me to know that there are 119 pages without checking that to be the case, but yes.
A supplemental bundle of 999 pages.
Yes.
Rather larger, yes.
I'll say yes to that. I know there's a bundle with a lot of pages.
Yes, hopefully the key documents will cross-reference to the chronology in our skeleton. And then an authorities bundle of 233 pages.
I'll take your word for it, but yes.
And then a supplemental authorities bundle provided by my learned friend, I think yesterday, with one additional case, the Wood and Capita case. Thank you.
Right.
Thank you very much. I'm glad that all made it in there. My lords, before I turn to the appeal in substance, then I need to, I think, make three short points at the outset relating to concessions that we made when seeking permission to appeal. And if I can trouble you to open the core bundle to page 32 and our appeal skeleton.
Yes.
You'll see at paragraphs 42 to 44, we made three proposals when seeking permission. The first, at paragraph 42, is that we would submit to an order under section 20 big C of the Landlord Act of 1985 in respect of this appeal. What that means is that if the lease gives us the power to charge legal costs through the service charge, a 20C order disallows that right in whole or in part. And as we explained, this isn't pure party-in-party litigation for us. It's important for us to know the meaning of this clause for the next 100 years. So we've consented to a section 20C order. So win, lose or draw.
Has that been made, or is that something
No, so
that will need to be made when we make an order?
At the end of the appeal, we'll record that the order is made. It hasn't been made yet, so we'll record that at the end. Win, lose or draw, that will be a clause of the order.
All right. Well, when we hand down our judgments to you in draft, we will no doubt ask you to agree the terms of an order, and please make sure that you include whatever needs to be included in that respect.
Of course, and the same for the other 2 points in 43 and 44. Paragraph 43, there are other leaseholders in this block who are not part of my learned friends group.
Yep.
For the FTC and the Upper Tribunal, we've accepted we'll apply the same result to them. We stand by that concession. And I'm not sure that'll need to be recorded in the order. It may be a recital, but we stand by that position. And then finally, because this is an appeal from a tribunal that's ordinarily a no-costs tribunal, we have suggested, and my learned friends accepted in her skeleton, that the court could exercise its powers under 5219, I think it is. So, absent unreasonable behaviour by one of us in the next few hours, it will be a no order as to costs appeal.
Yes.
Come what may. I thought it important to make that clear because although it's agreed in writing, it seems to be it's important for those who might be watching to understand that, and those of my learned friends' clients who sit behind understanding, that there will be no costs consequences arising out of the conclusion of today's appeal.
All right, well, we'll leave it to the two of you to ensure that what needs to be recorded in that respect in the order is in due course.
I'm very grateful.
Thank you.
My lords, ultimately, although this is an appeal of some importance, it's quite a short point. It's a question of construction of a fairly standard form of right to buy lease used by this authority and others. Factually, there's very little. There's material to look at, but there's no dispute, and it hasn't been throughout these proceedings. The authority is carrying out works to strengthen some large panel system buildings. And the question is, as a matter of principle, can it raise a service charge for those works under the terms of this lease? It's a question of contractual interpretation. The FTT and Upper Tribunal have each decided that the lease does not allow for such a charge. And the question for today is whether that's right. What today is not about, if I'm right and that in principle a charge can be made, it's not about how much should be charged or what payment terms might be available. My learned friends' clients have an extant argument not resolved yet by the FTT about the quantum and they say our costs are unreasonably high, and my lords may know, reasonableness is effectively the main protection against service charges conferred by statute. That dispute remains to be heard, because presently I haven't got past stage one. You don't need to worry about reasonableness if you have no contractual right, and I haven't got past the contractual right question. So that's all today is about, is whether in principle I have a right to charge for these works.
And what is the status of the works? Have they been done, or are they being done, or are they planned to be done?
My instructions as of 15 minutes ago is that they've been completed. We are currently in the snagging phase. There's been a particular problem that's been discovered relating to some paint work that's been used. The wrong kind of paint has been used on some steels. So that will need to be made good. But that, although it's an inconvenience for the leaseholders because they're still living in a building site, that has no impact on the costs. That's a matter between us and our contractors.
Yes.
Importantly, our position is that insofar as these are works of safety, which you've been saying they are consistently, we think the works that are needed to make this building safe have been done.
Yes.
My lords, in terms of how I'd like to use my time this morning, I do want to take you through some of the history of these buildings and the history of the large panel system design to understand effectively the historical problems that were discovered at the Ronan Point disaster in the late 60s, and then bring you up to date with the new batch of problems discovered in about 2017-18. I then want to look relatively briefly at the FTT and Upper Tribunal decisions. And I will take them quite briefly. One, I assume you've read them.
Yes.
And secondly, this isn't one of those cases that turns on detailed analysis of the oral evidence and evaluative judgment. It's just, what do the words mean? So with the greatest respect to the FTT and to Judge Cook, this isn't one of those cases where one starts from a position of respect for a lower tribunal decision maker. It's just, what do the words mean? And if this court takes a different view, it takes a different view. I'll then turn to the lease terms and make the submissions under ground 1 and ground 2, and I'll deal with the respondent's notice at the same time, because it seems to me it probably comes up in relation to ground 1, rather than as a freestanding point. All being well, I'll be done well before the short adjournment, but let's see. So, in terms of the history of these buildings then, can I ask you to start in the core bundle at page 33, where we've produced a chronology. And with apologies to my learned friend who'll be hearing this for the third time, and I suspect could no doubt recite it now. I won't take you through everything, but these are the key dates, and I'll take you to the key material where we need to. The first 5 entries on the chronology I can probably ask you to take as read. We're dealing with an estate that, before the 1960s, was owned and operated by the Barley Mow Brewing Company. And sometime in the early 1960s, the then London County Council acquired it for use as housing. And the London County Council started the process of erecting, at the time, 3 large panel systems buildings. There are only 2 left now. One got demolished as part of the Limehouse Tunnel works. And the LPS buildings, as you may have seen from the material, were a form of building that was very briefly popular in the early to mid 1960s. The critical way it differs from normal construction is that you manufacture the huge slabs of concrete off-site. You bring them to site, and then rather than using columns to bear weight, you use the external wall of the building, these enormous sheets of cement that have been built, as providing all of the structural support. There's a description of it from an academic text in the supplementary bundle at pages 463 to 464. And when you describe it that way, you can immediately see both the attraction and the problem. The attraction is it's incredibly cheap because you can design it all off-site. Much cheaper than trying to build on site. And the problem is that if you're relying on the external wall for all of the structural stability, if anything happens to that wall, the building's structure is compromised. And that's what's happened on the fifth entry in that chronology, on the 16th of May 1968, the well-known Ronan Point disaster. That was an LPS building which had a piped gas explosion in one of the kitchens of the flats. That caused one of the external walls to be compromised, with the result that the floors above collapsed. 4 people were killed and 17 were badly injured.
Yes.
And it was after the Ronan Point disaster that central and local government began to grapple with the implications of all these LPS buildings that have been thrown up. And if I can take you to entry 6 in the chronology, the 22nd of October 1968, the GLC, as it's become by then, it's transferred from the LCC to the GLC. If we go to supplemental bundle, page 453, they start grappling with the consequences of the innumerable number of LPS buildings they own throughout London.
Give me the page reference.
That's supplemental bundle 453, my lord.
That's printed 453.
Printed 453, yes. And I'm afraid it has to be turned 90 degrees to be read.
Can't be.
Finding these was a labour of love on behalf of my instructing officers, trawling through the old LCC archives and other archives to find material going back this far. You should have there item 33, report number 2 of the Housing Committee. It's dated the 6th of March 1969, but we know from entry 2, where they're talking about another LPS building they had in Camelot Street. You see there the date of the 22nd of October, the chairman of the council had approved reinforcement works. So pretty much it seems as soon as Ronan Point happens, the GLC starts investigating the necessary improvement works. And in November 1968, government published Circular 6268, detailing what it recommended should be done with LPS buildings. And Circular 6268 is at pages 484 to 487. If we turn that up. And you see on 484 in the top right corner, Circular 6268 from the then Ministry of Housing and Local Government. It notes at paragraph 1 that there'd been a statement in the House on the 6th of November in response to a tribunal inquiry into the collapse. It notes at paragraph 2 the tribunal had recommended that all blocks over 6 stories should be appraised to see whether they're susceptible to progressive collapse and whether they adequately resist maximum wind loadings and their behaviour in the event of a fire. The Minister accepted the recommendation and impressed most strongly on local authorities who do have such buildings and not started such appraisals the need to put the work in hand. Paragraph 5, the circular draws attention to the fact that technical advice about the standards to be applied is contained in the appendix to the circular. Paragraph 8, it asks for proposals to be submitted to relevant central government headquarters. And then paragraph 9, as an immediate precautionary measure, any gas supply must be cut off in the blocks to be appraised, unless after the most careful consideration, the local authority is fully satisfied they're not susceptible to progressive collapse. And then over the page at 487, these are the technical standards that are identified. And you see at paragraph 1, the circular says there are 2 ways of avoiding progressive collapse. Method A is to provide alternative paths of support to carry the load, assuming the removal of a critical section of the load-bearing wall. So essentially, assume the wall fails, you install some other way of dealing with the structural pressures. Or method B, essentially improve the stiffness and continuity of the building. It's method A that's used here, and method A is described further at paragraph 4 on 487. The details of the basic standard. You see there are steel connections to be provided in at least the following positions: between floor and roof slab of the supporting external load-bearing wall panels, between the adjacent floor or roof slabs over internal load-bearing walls, and between adjacent external load-bearing wall panels and at least the horizontal joints at the top of the panels. So essentially you're no longer relying upon the wall as the sole source of structural stability. We're going to use steel. Staying in the chronology at page 33 of the core bundle, that was 15th of November, where the circular was published. It was followed just over a month later, to the 20th of December 68, by a second circular, circular 7168, providing further details. Circular 7168 is at page 490. And if you see at page 490, what this is a note from the Institution of Structural Engineers that the Minister commends to the attention of local authorities. There's nothing more in this in terms of the technical detail that wasn't covered by 6268. I just note at paragraph 5 because this is a neat summary of the problem. And it introduces a concept that becomes quite important later. It introduces the concept, you'll see, of abnormal loading conditions. So we'll see that later on the distinction gets drawn between normal and abnormal loading. In simple terms, abnormal loading is where something unusual has happened, an explosion, a car crash, etc. Normal is day-to-day use. And it simply makes the point in the last sentence. Some forms of building structure, particularly industrialised large panel systems, have little reserve strength to resist forces not specifically catered for in the design. And that's the problem. With those two circulars published, if we can stay in the core bundle at page 34 now. I can just take you through the 3 entries for February, March and June 69, and then we'll go to look at some more material. You see in February 69, the GLC start to carry out consultations and experiments to work out how to overcome the problems across their stock. In March 69, they resolved to comply with Circular 6268. That's important because if you jump back to the 15th of November 68 entry, the GLC were initially using a slightly lower standard. So they resolved to then comply with the circular. And 24th of June 69, they resolved to take appropriate measures, including strengthening if necessary, in respect of their LPS buildings. We've got the references for all of those. They're just minutes, so I won't take you to them. What I do want to take you to, though, is the 2nd of October 69, because now we start to get into material about this building rather than the GLC stock as a whole. So the 2nd of October 69, the material is at page 456. And you see under item 12, report number 1 of the Housing Committee, housing blocks safeguarding against progressive collapse, 2nd of October 69. 3 paragraphs from the end starting, we have caused a document to be prepared. So the GLC has drawn up a standard to be applied to all of its stock, taking into account the 2 circulars. They'll update it as and when further information becomes available. And we know that that work then starts to be carried out in late 1969, and we know that it was done to this building because we've managed to find a photo of the work being done at this building at page 497. Tucked away in the London County Council's photographic archives, we've managed to find a workman drilling holes into the development, into the properties of this development. And the drilling is what starts to tip us off that it's method A that's been used. You're going to be inserting steels in there rather than strengthening the walls by making them more rigid. And then as far as anyone can tell, those works are completed, and as far as anyone's aware, they achieve their purpose. The trail just runs dead. There's no records of problems being notified. There's no record at central or local level of recalcitrant local authorities dragging their feet on doing the work. It just seems to be that the works required were done. And then in 1986, looking at the last entry on page 34 of the chronology, of course, then this building is transferred to the authority. Following the GLC abolition, it passes over to Tower Hamlets. In August 1988 and September 1988, 2 reports are commissioned in the context of the then proposed new Limehouse-linked tunnel, which is going to be running very close to this development here. The first is August 1988 from Scott Wilson Kirkpatrick, and you find that in that supplemental bundle at page 62. Now this is a report for the local authority. See that other reports are for the London Dockland Development Corporation, etc. But this is for the local authority. And we see at page 69 that these consultants have managed to find out a bit more information about the work that was done in the late 60s. If you go to page 69, second paragraph following the collapse. They've managed to track down some drawings of the strengthening from September 1969. And then since then, the next paragraph starting a low impulse radar survey. There's no evidence of any further structural work before the GLC was abolished and transferred over to us. So it looks like the 1969 strengthening work is the last work. What they have found evidence of is some sealing, which is irrelevant to the questions here. Now it's a very detailed report. If we just jump to page 87, paragraph 8.7, they inspect certain of the flats. Flat 36 Risby will be the one that gets demolished as part of Limehouse Link, but 50 maltings. They've been inspected. They found evidence of the strengthening angles having been installed in accordance with the drawings in our possession. They find some minor irregularities, but they don't consider it to be of any structural significance. And then at page 126, in their conclusions, you see the paragraph, first paragraph on the conclusion, starting generally to a greater or lesser extent. I can ask my lords to read that. So they find, in that first paragraph, they find some evidence of design defects, but the second paragraph is important. They're not structurally significant under normal loading conditions. They have some concerns about whether there'd be sufficient structural strength, structural integrity in the event of an abnormal load. But they don't recommend any particular work. Contrast that with the penultimate paragraph where they do recommend, for example, some fire precaution work needs to be carried out. That's followed a month later by a report for the London Dockland Development Corporation, which starts at page 131. And 132, their synopsis. Paragraph 3, starting following the partial collapse, is quite an important paragraph. They also find evidence of the strengthening work done 1968, possibly 1969. And then over at page 133, the last paragraph, within the limitations of their survey, nothing's been observed that would suggest the buildings are in any structural distress. They've coped well under normal, dead, imposed and wing loads. They identify areas which could be further investigated. It's worth noting at paragraph 100, at page 143, paragraph 2.6a, they appear to have identified a source of information that the other consultants didn't identify. They've managed to track down Phillips Consultants Limited, who were the structural engineers who designed the blocks. And they've managed to provide details of the strengthening, details of the joints, etc. Over the page at 144, they've managed to track down the local authority officer responsible for effectively keeping hold of most of the drawings. At 152, under the heading Structural Strengthening, again, they've managed to find evidence that the strengthening that we all think happened in 68-69 did indeed happen. They found evidence of the new steel angles that were inserted. And at 163, paragraph 4.1, don't express any particular concerns about normal loading. And over at 166, under abnormal loading, they do express some concerns about the position on abnormal loading. And they note at 4.14 that to mitigate against those risks, there's effectively no gas being provided. So you can there's the risk of the explosion that happened at Roman Point. So by the late 1980s or early 1990s, the position seems to be that there were no concerns about normal loading. And some, I don't want to say relatively minor, but some things flagged up about abnormal loading, but no one proposing any particular work. So some concerns being stressed, but nothing being identified to be done. The situation changes in August 2017. If we can go to page 509. Essentially, the London Borough of Southwark have discovered a significant problem with some of its LPS buildings. You wouldn't know it from the description in the letters, but the cracks were enormous. You could put your hand through some of these cracks. So Southwark had identified significant cracking in 4 of their LPS buildings. Engineers have been instructed, and in the course of instructing engineers, Southwark had identified another problem, which is they still had a piped gas supply to those blocks, which should have been stopped in 1968. The 4th paragraph down accords with what we can tell from our analysis of the historical records.
Can I just ask one question?
Oh, yes.
So you said nothing really occurred until 2017, but is it right that the residents were complaining about the cracks for some years before that?
In Southwark's one, or here?
Well, here.
I don't.
I mean, it is. I know it's the case in Southwark, but
I don't know, and I don't think we've looked at in the course of this case all the repair and record logs for each individual property here. It's not been any part of my case that I've been responding to or receiving complaints during this period. I will be corrected by my learned friend if I've overlooked it, but her pleaded position in the FTT is that the authority knows there are problems because of those 2 1988 reports. But I don't recall there being a pleading like you'd see in a traditional disrepair case of there were complaints on the 1st of January, 3rd of January, whatever it may be. Which isn't quite the answer to my Lord's question, but I think that's the best answer I can give. In Southwark's one, I do know the position, which is there were complaints for a long period of time.
Yes.
Because the cracks are enormous. A cursory Google search will find BBC News stories about it going back years and years.
okay. All right.
And just noting the 4th paragraph in that government letter, their view coincides with what we think the position is, having looked at the historical records. We think there were strengthening works that were done, and that was to make them safe in response to the Ronan Point disaster. The point is that Southwark's is they couldn't find any record of that. And in light of that, the top paragraph on page 510, the government advised local authorities to investigate LPS buildings in their area with piped gas and satisfy themselves as to the safety. Now, we don't have piped gas here, but we still nonetheless decide to investigate the safety of our LPS buildings. And in January 2018, we receive a report from Wild Carter Clack, which starts on page 511. Now, this is just their desktop study that says on 511, so this is their initial advice to us. The executive summary at 513 to 515 is probably all we need. And helpfully it pulls together most of what I've taken you through so far already. Explains in paragraph 1 that they're built using LPS construction methods, which thought construction started prior to Ronan Point, not occupied until after the strengthening work had been done. The strengthening work was designed to satisfy the Ronan Point inquiry reports. They've got access to the Scott Wilson Kirkpatrick report, which is the August 1988 report. They read that report, the third paragraph down, as saying that the building did comply with the requirements for the Ronan Point inquiry. And that was because you only had to reach the 17 kN per metre squared because there was no piped gas. You'll recall that the report flagged the 34 figure, and they pointed out, well, that's if you have piped gas. You can go for half that if there's no piped gas. They then identified that the Scott Wilson Kirkpatrick report looked at the normal loading, found it to be adequate. Reviewing 514 is essentially summarising all of the different sources of information they've looked at. And over at 515, paragraph starting since 1989, in that paragraph, these consultants are making the point that we can't necessarily safely rely on assumptions that were made based on previous standards. And underneath that, the buildings are now 50 years old. And they recommend a full internal and external intrusive investigation. That's carried out and reported to the authority in July 2018. And that report is at page 222.
I'm sorry, what page did you say?
222. So it's the same consultants, Wild Carter Clack, having done their desktop survey recommending a full structural survey, now do that structural survey for us. And we can pick it up at 233, where they identified slabs, normal loading and abnormal loading. And under 6.3 normal loading, their conclusion, for the first time, certainly for the first time anything like as clearly as this, is that there is a normal loading problem. The slab reinforcement bars are overstressed based on their diameter and the field test undertaken to estimate the steel yield strength. They're under capacity based on normal dwelling loading. For abnormal loading, you see they're applying the 17 kN per meter squared because there's a non-piped gas explosion because there's no gas supplied to this building. They find that the non-load bearing partition walls have adequate capacity, but the severe non-piped gas explosion in the adjoining flank walls, there's a risk that the associated slab below will fail. This results in destabilisation and potential disproportionate collapse. And then their conclusion over the page of 234 under the heading slabs. The normal loading is found to be under capacity.
Is this because British standards have changed, or?
There is a change in British standards. We went through some of this.
And you just drew attention to the fact that this is the first time somebody's raised an issue about the adequacy under normal loading.
It seems as though the building research establishment's undertaken some independent research along the way, which must have led to a change in the appropriate loading standards.
Yes, I did a slightly more detailed note for the Upper Tribunal, so I'm just looking at my references there. It's if you go in the supplemental bundle at page 779, this is a witness statement from our expert evidence. Our expert, sorry. And go to paragraph 7 on page 780. He explains there that there was a change in the BRE's handbook for LPS buildings in 2012, which changed how the understanding of how buildings were to be assessed and how they should behave. So
Seems to be referenced in the early material.
Absolutely, yes.
Material you'll take us to earlier. Yeah.
Yes.
And on the face of it, it seems a bit odd to say in the one breath that they've stood for 50 years and then that they're unsafe under normal loading.
Can I respond to the other reference from my lord there? Page 801 is the other reference making the same point, and then I'll come back to my lord's question. 801 is an extract of a report that Arup produced for the local authority. You see under the heading BRA research on LPS blocks, BRE guidance on assessing LPS blocks. And they both refer back to the 2012 change.
Yeah.
Turning to my lord's question, I don't mean this as a trite or flippant answer, but the job of the authority, it seems to me respectfully, is to act on the best advice of the professional advisors. And if the professional advisors are advising that nowadays you should regard this as a safety problem, in my submission, the authority it'd be very difficult for a responsible local authority not to respond in kind. Notwithstanding my Lord's common sense point, it's been standing for all this time. But having been advised now by two reports.
No, I see that. If standards change, then that may follow.
Well, it starts to get us into a debate that I fear may be rather sterile, but I think it's worth putting down the marker at this stage. Merely because standards change doesn't mean that it has become unsafe where it wasn't. The true analysis may well be it was always unsafe, but the standards were wrong. So it doesn't necessarily follow that the change in standards is the cause or effect of the unsafety. The physical condition of the building hasn't changed. Our understanding of risk may have changed.
But that's an issue which is not related to the antiquity of the building, but to the architectural parameters that were brought to bear at the time when it was designed and constructed.
Yes, it's a consequence of LPS buildings. But But my submission will be when we get to ground one, that doesn't change the fundamental fact that these are works being done to ensure the safety of the building and the occupiers.
Your point is the building may always have been unsafe. It's just we now appreciate rather better because of the change of regulations or specifications that is so.
Yes, or simply better understanding on the part of the BRE.
Yeah.
Exactly. The building has.
My question wasn't actually as loaded as the debate to which it has led.
No.
It was just trying to put a frame of reference about your observation, which seemed to draw some significance about the fact that this was the first time that somebody had drawn attention to the normal loading safety of the building.
Well, it's an important matter for the local authority to make clear, but they don't want it to be suggested they've been sitting on a dangerous building for some time. You will appreciate, in light of the events around, not limited to, including the Grenfell Tower, local authorities would not want it to be thought that they were aware of problems and did nothing about them. This authority's position is, it thought, when it acquired this building in 1986, as far as it was aware, the 69 works had been done and solved the problem. The 88 reports don't recommend anything. It's 2017, and that government letter, which prompts us to go and look at our own stock again. We have two reports. The desktop report says you should have a full structural survey. The structural survey says you have a normal load problem. That is factually the first time anyone's been flagging that up, because the problem with Ronan Point wasn't normal load. It wasn't that the occupiers were just walking up and down their floors. It was the explosion. So unsurprisingly, everything in 68, 69 is focused on the abnormal loading problem. But for the purpose of the resolution of the appeal and the purpose of the submissions of law are made, what matters in my submission is that these are works of safety. And if they are, I say they'll fall within clause 550.
Yes.
Yes, I was just finishing on 234 and the conclusions of the July report, July 2018 report. You see there under slabs, slabs found to be under capacity for normal load. And then another problem is raised in respect of a non-piped gas explosion. So if anyone had bottled gas or cylinders or something similarly volatile, that mustn't be stored in the building. Won't surprise you to learn that there are prohibitions against that generally, but that's the advice we're getting in 2018. So armed with that information, the local authority decides to undertake remedial works. I won't take you through all of the specification plans, etc., because they're not relevant to the issue on this appeal. I'll take you, if I may, though, to page 556. Because, as I'm sure my lords all know, when a landlord is carrying out expensive major works, the statute prescribes a consultation process with those who are going to be required to pay, the leaseholders. And this is an example of one of the letters that's sent out. So May 2020. Under why do we need to do the work? In a paragraph, they summarise developments since 2017. Government issued guidance to local authorities advising them to check the condition of their LPS buildings. Following the review by the engineers, it was found that some of the concrete slab floors do not meet the recommended safety standard required by structural engineers for normal loads and require strengthening. The blocks do not comply with the recommendations for the prevention of disproportionate collapse in the 2012 guidance produced by the BRE. This means this means that an accidental extreme event such as a gas explosion or vehicle impact could lead to a collapse of a disproportionately large part of the building. Jumping down a paragraph, the proposed works are required to secure the safety of residents and the building. proposed that the contract for the programme of works will carry out structural strengthening to both buildings. And then under what do we plan to do? This is essentially the high-level summary of the works that are planned. Install a steel frame, install external reinforcements and associated works. And then you get more detail under each of the underlined headings. So removal of certain walls, install steel supports, etc., etc. There is no getting away from the fact that works of this scale are likely to be very expensive, and this notice doesn't shy away from that. Go to page 559. The estimated costs for both blocks are said to be 8.06 million, so 4.03 million for each block. Splitting it by flat, £73,000 per flat. Now some of that's going to fall on us, of course, because all our tenanted flats, it's held by our secure tenants, we have to pay for. But for the ones that are sold on long leases, the service charge mechanism will kick in. Faced with that information, my learned friends' clients, not unreasonably, we don't criticise them for this, go to the First Tier Tribunal, as is their right in accordance with the statutory scheme, challenging that estimate of costs. You can challenge both estimated costs and actual costs in the FT2. And if you go in the supplemental bundle, page 13, we have their statement of case in the First Tier Tribunal. And we can...
Sorry, can you just give me the page?
Sorry, page 13 in the supplemental one. That's behind tab 2 if we're using paper. Tab 1 is the pro forma application form. Tab 2 is where we get the meat of the material. And it's paragraph 18 where my learned friend summarises her case in 4 propositions. So proposition 1 is just that they have no obligation to pay for these works because they don't fall within clause 5 of the lease. Proposition 2 is that even if they do fall within clause 5, then at least for some of the properties, there's what Judge Cook called the carve-out. There's a special temporal restriction under the terms of the lease as to what you could charge for certain periods of time.
That carve-out would apply, wouldn't it, even if it's not written in the lease as a result of the legislation? It looked to me as if the carve-out was essentially in the same terms as the legislation.
Not quite.
Right.
Because of how 125 notices now work. The carve-out is a slightly strange amalgam of how the right to buy provisions worked before the 1986 amendments and how they've worked afterwards. As a broad, high-level proposition, it is certainly true to say that right to buy leaseholders, whenever their lease was granted, have certain statutory protections in respect of service charges that go beyond normal leaseholders and go beyond the express terms of their leases. But we'll need to look at those when we come to the carve-out a bit later on, because part of my learned friend's argument in her respondent's notice is that the policy of the right to buy legislation informs what can be charged. And I want to take you through what that policy is, because there's an important change in 1986. But I'll grapple with that then if I can.
Right.
Proposition 3 is essentially the factual material to make good proposition 2 that's saying, well, look, you knew about all this within the reference period, so that the carve-out is going to kick in. And then proposition 4 is that even if all that's wrong, the service charges that you're demanding aren't reasonable. And I say, my lord will know that service charges have to be reasonably incurred and reasonable amount. We are still at proposition 1 stage, because of course propositions 2, 3 and 4 only matter if there's a contractual obligation to pay in the first place. And turning then to what the FTT and the Upper Tribunal said as to why there is no obligation to pay.
At some point, although you say 4 doesn't arise until 1 is satisfied, at some point, I just put a little marker down, I'd like you to walk me through what you say about insurance.
In what particular respect that we could or should have insured for some of these costs?
Yeah, I mean, there are insurance provisions in the lease that
There
we
are
need to look at, and so can, as and when you get them and look, it's just that the insurance point is made at the end of 4, albeit in a different context.
Yes.
But can you, when you're going through the contractual provisions, also factor in the insuring obligations?
Of course. Let me just make a note of that. Yeah, it's one of the other bits of clause 5. Yeah, I'll deal with that now. So then, looking at what the FTT and then the Upper Tribunal said, and then I'll come to the substantive submissions. The FTT decision is in the core bundle at page 82. So well, it starts at page 70, but 82 is probably where we can go for their conclusions. Paragraph 46 on page 82 is, it seems to me, what comes back as Millennium Friends Respondent's notice point. It's a policy argument about how you interpret these leases. The FTT says that it would be contrary to the purpose of the right to buy if the clause I rely upon, clause 550, was apt to catch this kind of work. And that comes back into response. Paragraph 47 is what becomes ground 1. The FTT says clause 550 wasn't intended to catch works of this particular nature. So then that becomes ground 1. And then paragraphs 49 to 51 are what becomes ground 2. And they reject the argument that the definition of total expenditure, which is what the leaseholders have to pay towards. It's a slightly odd way of doing it, because I haven't taken you to the leases yet, but just taking through the decisions. So ground 1 is about 550, ground 2 is about the definition of total expenditure, and they reject my argument that total expenditure has 2 elements to it, all of the clause 55 costs plus other things. So that becomes ground 2. That's my lord's slightly baffled by this. It will hopefully make more sense in about 10 minutes' time when I get there.
I mean, clause 550 is not itself concerned with who has to pay for the works.
No.
It's about who has the obligation to carry them out. And one might think it would be unsurprising that there be an obligation on the landlord to put right any structural defects affecting the safety of the building. But that doesn't tell you who has to pay for those works. For that, you have to look at
it's scheduled.
Total expenditure and,
Yes.
and the definition there to see what falls within
Yes,
and what falls outside the
correct.
tenant's obligation to pay.
Correct. And so the argument when they come to it is total expenditure. I say total expenditure includes all of the expenses incurred under clause 5.5, which in clause 550, that's ground 1. So we have to grapple with whether or not I am acting under clause 5.5. If I'm not acting under clause 5.5, a covenant that says you will pay towards the clause 5.5 costs just isn't engaged. So I will have to show you that these are works of safety that engage 550, because if they're not, game over.
But if they're not, then where was the landlord's obligation to carry out the work to make the building safe? It could have just said, over to you chaps.
No.
No?
Because of the implied covenant in Schedule 6 of the Housing Act 1985, it is always a term of a right to buy lease that landlords must deal with repairs to the structure of the exterior and make good structural defects. Let me just show you that now. We're going slightly out of order, but I think this might be helpful. If we go in the authorities bundle to tab 12, page 209, Schedule 6, paragraph 14 of the Housing Act 1985.
Sorry, could I have the reference again?
Sorry, authorities, tab 12, page 209.
209.
And we're now in Schedule 6, paragraph 14 of the Housing Act 1985. So you see paragraph 14.1, this paragraph applies where the dwelling house is a flat. There are implied covenants by the landlord to keep and repair the structure and the exterior of the dwelling house and of the building which it is situated, and to make good any defect affecting that structure. So when a right to buy lease is granted, irrespective of what you covenant expressly, that goes in. So when my lord said to me, it would be sensible for landlords to have that obligation, the answer is not only is it sensible, it is the law, at least for right to buy leases. They must do that. So that gives rise to two questions. Are we acting under clause 5.5? It seems to me it's question one. And I say we are. We are doing works of safety, and the definition of total expenditure, which is the things to which the leaseholders have to contribute, includes our clause 5.5 obligations.
But if you're not within 5.5, the point is if you're not within 5.50, it doesn't mean that in fact you aren't under an obligation to do it. You are,
Yeah.
It's just you can't recover it.
No, that's where ground 2 comes into play. Because in ground 2, I say that the definition of total expenditure isn't limited to the 5.5 obligations. It includes such other things as may be desirable for the proper administration of the building. We'll come to the wording in a moment. So you could charge it under the second part of total expenditure. So let me show you that now. This is out of order, but I think this is important. If we go in the supplemental bundle,
Is there any other statutory provision before we get to look at the lease that we have to read into the lease?
not to read in, you need to also flag up as sitting with 14. You look also at 16A on 213. So what 16A says is that the drafter of the lease may require the tenant to bear a reasonable part of the costs incurred in discharging the implied covenants under paragraph 14.2. So the way the right to buy legislation works is that you have certain covenants which are implied whether you like it or not. And then you fall back on normal contractual interpretation to see whether they're recoverable as service charges or not. And this isn't flagged in Malone Friend's skeleton, but from the passages she's sidelined, I can see where she's going with this. That's what was happening in the Plymouth case that was in the authorities bundle, where the landlord had an obligation by virtue of the implied covenant to do something that it couldn't charge for. To which this court just said, tough. That's how leases work. You might have unfunded obligations. The point is you're allowed to have a covenant that charges for it. So it comes back to the question of construction. Does this lease allow for the charge? And the divide between these two routes,
Well, you're not, are you? You're allowed to have a covenant that charges for it, subject to the carve-out.
subject to the carve-out and,
So-
and section
so-
125 notices, yes. So in individual cases, there may be individual provisions, but in principle, there's nothing objectionable to a lease charging for it.
I thought the at any rate the original right to buy legislation rendered some provisions which make you charge void.
So I think my lord has got parts of the pre-1986 position in mind.
Yes.
So in pre-19, we can look at this in Payne and Barnett, which is in the authorities bundle. Essentially, there's a change in how service charges are dealt with in 1986 in the right to buy legislation. And in very, very simple terms, post 1986, what you get is a 5-year transition window. You get given what's called a section 125 notice, which tells you what you're going to be charged for the next 5 years, and subject only to inflation uplifts, the authority can't go beyond it. So if it happens that a major works programme falls within those 5 years and you didn't put it in your 125 notice, tough. It was different pre-1986. So we can look at that when we come to the respondent's notice point. I just need to pick up on my lord's question. I think the question from all three of my lords is how this charging works. In the supplemental bundle, can we just go to page 43? Because this is the distinction between ground 1 and ground 2. So we see at 43, fifth schedule of the service charge, the total expenditure. This is the thing they're going to be required to pay towards. Total expenditure means the total expenditure incurred by the lessors in any accounting period in carrying out their obligations under clause 5.5 of this lease, less any sums expended from the money set aside under 5.5p of this lease. And just stop there for a minute. So that would be charging route number 1. If I'm acting under 5.5, and I say I'm acting under 5.5, then subject to the vagaries of right to buy legislation, I can charge that because that covenant lets me. If I'm not acting under 5.5, if I'm acting under Schedule 6, Paragraph 14, Housing Act 1985, I can still charge for it under total expenditure. And that's because, turn over to page 44, if you see the second line ending, making little structural defects, just put a line around that for the minute. That structural defects bit is the carve out. It's the bit starting and any other costs and expenses, because that's in all the leases. So I can charge total expenditure for my costs incurred in carrying out my obligations under 5.5, ... and any other costs or expenses reasonably and properly incurred in connection with the building, including without prejudice to the generality of the foregoing, the cost of employing the managing agents, the cost of the accountant or surveyor, ... fair rent for any caretaker flat, etc. So that becomes ground 2, that I have a right to charge for any other costs and expenses reasonably and properly incurred in connection with the building. So if I'm not acting under 5.5, if in fact what I'm doing...
So, sorry, just to be clear, you're saying that all the other words in between, as well, the start of this definition of total expenditure, and those words, and any other costs and expenses reasonably and properly incurred, can be ignored for the purposes of interpretation.
So let me just show you what I'm saying here. If you go to 43, it's the 2 different models of lease, and we can mark them up on one. 43, all of the leases say total expenditure means the total expenditure incurred down to 5.5p of this lease. 2 of them then have what we're calling the carve-out. And the carve-out is and save such repairs as amount to.
Yeah.
Which ends on page 44 at making good structural defects.
I mean, is it common ground that that's the way to read this?
It's not how we read them. It's two different aspects of the argument, and we'll come on to what the arguments are.
Okay.
My case is I am carrying out works of safety under 550, and so I can charge for it under those opening lines.
Yeah.
If I'm not carrying it out under 550, then the way I'm carrying it out must be the implied obligation to make good structural defects. And I say that if I can charge for that, it must be under the and any other costs and expenses reasonably and properly incurred. Now, my learned friend disputes both of those propositions. She says it's not 550 and it's not other costs and expenses reasonably and properly incurred. The relevance or otherwise of that carve-out we'll deal with when we come to the two leases who've got that form of carve-out. But for the purposes of trying to set the scene still, those are what I say the two charging routes are. It's either 550, or if it's some other route, such as the implied covenant, it's any other cost or expenses reasonably and properly incurred. Ground 1 is 550, ground 2 is any other cost and expenses reasonably incurred. And I'm trying not to get too far ahead of myself because we'll come to the arguments in a moment, but those are the two routes. And if either of them is successful, that's enough to have the appeal allowed. If neither of them is successful, then we've done these works, we'd have done them anyway. We just can't charge for them. That's the issue on the appeal. Looking then at what the Upper Tribunal decided, back in the core bundle, Judge Cook's decision starts at page 41. And her paragraphs 16 and 17, quite helpful to have to hand to avoid us having to keep going through all the different leases. Paragraph 16, all of the leases contain the 550 covenant, and I'll be relying on 550 saying that what we are doing is a work, installation, act, matter or thing which is necessary or advisable for the proper safety of the building. And then at paragraph 17, they all contain a covenant to pay an interim charge and service charge in the manner provided for in the 5th schedule. The 5th schedule is as follows in all of the leases, except that 2 of the leases, the earliest 2, have the words in italics. So for all but 2 of them, the covenant reads, total expenditure incurred by the lessors in any accounting period in carrying out their obligations under 5.5, less sums expended from the money set aside under 5.5p of this lease, ignore all the italics, and expenses reasonably and properly incurred. Whereas for 2 of them, you have the italics carve out. And that might mean we have different answers for different leases. That's an obvious possible consequence of different drafting. Judge Cook's analysis of the 550 clause starts at paragraph 47. And after reciting the competing arguments at paragraph 52, she frames the issue this way. Is it intended to encompass anything so far-reaching as an obligation to remedy structural defects?
I'm sorry, I've missed the page.
Sorry, page 52, paragraph 52.
52.
After she sets out our competing arguments, she frames the issue that way at paragraph 52.
Well, if you ask that question by reference to the two leases which do have the additional wording, the definition is obviously saying something about remedying of structural defects and saying that in some cases they have to be paid for and in other cases they don't, isn't it?
So my criticism when I get to ground one will be Judge Cook falls into error at paragraph 52. That's the wrong way of framing the question. She should have asked herself, what does the fifth schedule oblige someone to pay for? And it obliges them to pay for anything that falls within clause 5.5. So can this be said to be works of safety? And if she'd asked that question, she would have said yes. So in many respects, my ground one submission could be as simple as that. She's asked herself the wrong question. But her analysis seems to me to start at 54. I just want to draw out a few points from 54 that were clearly particularly important to her judgment. It's the third line down, starting, but this clause is necessarily unclear. In my submission, that again is where she's falling into error.
So have I missed something somewhere? Have we actually not looked at the relevant clauses yet?
We haven't yet. I do want to come to the leases. I'll do the decisions first. If we're happy to do the leases now.
But okay, as long as I haven't missed anything.
No, no,
I mean, I think the clauses, speaking entirely for myself, I mean, it might be useful to look actually at the clauses in a little more detail before we get to.
I'm
comments made
perfectly
by the
happy
tribunal,
to change order then. I'll move into the substance of ground one and looking at the leases. So let's go straight to one of the leases then. In the supplemental bundle, starting at page 23, this is the lease of 7 Malting. Now this one does have the carve out, which is why it's quite a useful one to do, because we can just put our highlighter over the words that don't appear in the other leases. So after the initial, definitional and introductory covenants, you need page 30, clause 4.4, which is the top of the page, the leaseholders covenant. Clause 4.4, the leaseholders covenant is to pay the interim charge and the service charge at the times and in the manner provided in the 5th schedule hereto, both charges to be recoverable in default as rent in arrears. So that's their obligation to pay. You go to the 5th schedule to find out what they have to pay for. The 5th schedule starts on page 43. And it's the definition of total expenditure.
Just before you get there, you're going to come back to.
I'm going to come back to 5.5 because the Schedule 5 then takes us to clause 5.5. So I'll do it in the order the clauses identify them. So the 5th schedule, which tells us what they're going to pay towards, they're going to pay towards this thing called the total expenditure, which means the total expenditure incurred by the lessors in any accounting period in carrying out their obligations under clause 5.5 of this lease, less sums expended from money set aside under 55p of this lease. And let's just stop there for a moment, because then we start to get into the carve-out. So let's go back to 5.5 to see what could fall within it. Because if you don't fall within 5.5, no one cares about the carve-out anyway. So let's go to 5.5, which is on page 30. So subject to and conditional upon payment being made by the lessee of the interim charge and the service charge at the times and in the manner hereinbefore provided, over the page here. Firstly, to maintain and keep in good and substantial repair and condition the main structure. Paragraph Roman numeral 2, the service media. Roman numeral 3, the common parts. Roman numeral 4, boundary walls. Roman numeral 5, any caretaker's flat. And Roman numeral 6, anything not included above.
And the reason it's not said that that catches the works is because of the opening words of A. Is that right?
Yes, I have argued in the FTC and the Upper Tribunal that you could get these works under a maintenance covenant. I've lost that twice and I didn't renew that. I've never argued you can do it under a repairing covenant, because repairing covenants subject to intervention by the Supreme Court require there to be a deterioration in condition, and the evidence doesn't suggest that. The evidence suggests these buildings have always been in this condition, or any deterioration is so de minimis as to make no significant difference. So I argued maintenance. I argued maintenance was about trying to achieve a functional state, and having lost that twice, I haven't pushed it again. You've then got B, as and when the landlord deems necessary, and you have here the painting covenants in 1, 2 and 3. 1 is essentially painting the outside. 2 is painting the inside. 3 is the caretaker's flat. C is the insurance covenant. The landlord is required to insure and keep insured against loss or damage by, and then a very long list of things: fire, explosion, lightning, thunderbolt, earthquake, riot, etc. Breakage of glass and sanitary fittings, accidental damage, homeowner's liability for accidents, and then we have details about the level of insurance to be affected. It's got to be against such risks as are usually covered by a flat owner's comprehensive policy. And then towards the end of that covenant, the capital provided always, again, the usual covenant dealing with what happens if you can't rebuild, where the money will go, etc. And then over the page, Roman numeral 2, the leaseholders are entitled to see the certificate of insurance. Roman numeral D then is to provide common parts, lighting, window cleaning and certain furnishings. E is to pay the taxes that relate to the land. F is a power to retain staff, caretakers, etc. And if so, to recover their costs and any accommodation costs provided to them. So the notional rent of the caretaker, that kind of thing. G and H relate to the heating and hot water system. J, power to retain servants or managing agents to manage the building, and then to charge their costs as a service charge. K relates to a rented communal television aerial. L is the firefighting equipment. M is the lift. N is what's called the electric porter system. It's an electric entry system is what it means. And then O, which is the one we rely upon. without prejudice to the foregoing, to do or cause to be done all such works, installations, acts, matters and things as may in the absolute discretion of the lessors be considered necessary or advisable for the proper management, maintenance, safety, amenity or administration of the building.
Before we come back and no doubt look further at O, going back to the insurance provision, which is C, and it goes on for over a page, and I'm taking it all in, but it looks as if the obligation there is to have insurance which will protect against the consequences of structural failure, but not a decision to make good a structural defect which has been identified. But when you get to the fifth schedule, at any rate where you have the additional wording, there is provision for insurance against the making good of structural defects, which seems to go beyond the landlord's obligation, but the landlord can insure against that if such insurance is available in the insurance market, I suppose, and charge it to the tenant. Is that right?
Yes, so this picks one question my lord asked me to deal with earlier. Clause 5.5c requires you to have insurance against the costs arising from a particular thing. Fire which causes damage, explosion which causes damage, etc.
Yeah, well, if you have an explosion and part of the consequence of the explosion is that the building collapses, then that's covered or has to be covered by your insurance.
Yes.
But if you say to yourself, or a structural engineer says to you, this building is not safe, it needs work done on it, that would not be covered by the insurance which is referred to in 5.5c.
I agree. Yes, that's my reading of the clause as well. The carve out, going to page 43 then, does reference that an insurance against structural defects as well. So let's just look at the nature of the carve out. You only get to the carve out if we're dealing with a charge that already fell within 5.5, because you don't need the carve out if it hasn't fallen within 5.5. In many respects, that's my starting point. So because the carve-out relates to structural defects, that's a pretty good indication that clause 5.5 doesn't exclude them.
Well, suppose you're right, and that 550 includes making the building safe, and that's what you were doing here. And suppose you had insurance against the cost of that work, which you're entitled to make the tenant pay for under the fifth schedule. In other words, the tenant has to pay the premium. It's a bit odd, isn't it? If the tenant who has paid the premium then has to pay for the cost of the works, because that's what he's been paying for insurance against.
So there's two answers to that. The simple answer is a landlord who tried to levy a service charge bill for a cost that was insured would lose on reasonably incurred. Costs that he was demanding of the leaseholder clearly wouldn't be reasonably incurred. That is a decision of the Old Lands Tribunal, as was a decision I'm very fond of. It's my first reported case, a case called Continental Properties and White. You can't have it through both ways. If you've been paid by an insurance company, you can't reasonably demand it of the leaseholder. But the better answer is actually by looking and understanding just how narrow this carve-out is, and why in my submission the carve-out isn't really that helpful to us in resolving what's in the appeal. And we need to look at the wording quite carefully. So we know that clause 5.5 has otherwise enabled you to charge for this, because the carve-out is excluding save such repairs as amount to the making good of structural defects. So just pausing there for a minute. The first thing is it's got to be a repair to make good a structural defect. And repairs would ordinarily fall within 5.5a, because that's the repairing covenant, not 5.5o. Other than, so the carve-out itself has an exception, other than structural defects already notified to the lessee, specified in the 6th schedule. So when they bought the lease, you could tell them there is a structural defect, it's in Schedule 6. And if so, they wouldn't get the benefit of the carve-out. Or of which the lessor, so the landlord, does not become aware earlier than 5 years from the date of this lease. So things that you only become aware of 5 years and a day after the grant of the lease aren't caught by the covenant either. What the covenant is doing is very, very close to how the right to buy works nowadays, which is the 5-year transition window. That's what 125 notices give you. It's not granting you a 125-year subsidy against ever paying for costs of dealing with structural defects. It's saying that if clause 5.5 bites and you are being charged for a repair which amounts to making good a structural defect, then in order to charge for it, it either needs to have been specified in the 6th schedule with no limitation of time, or it needs to have been one that the landlord became aware of no earlier than 5 years from the date of the lease. That isn't our case here.
What do you mean it isn't your case?
There's nothing in Schedule 6 in any of these leases excepting this. And one of the reasons why I kept stressing below and in the Upper Tribunal and again here, the fact that the chronology and the change, the gap between 67, 68 and then 2017, is because it's simply not the position that we knew about this at the date of the grant of the leases.
Well, you did, but you just thought that it had been remedied.
That's not a structural defect then. But the real answer, because it...
Didn't you lose that point before the FTT, and have you appealed it? I'm looking at
I'm not sure
paragraphs 53 and 54.
Sorry, you knew there was a... I'll come back after you answer my Lord's question.
As I understand it there, your argument to the FTT was that what emerged in 2018 was a new problem, a new defect. But they said no. There was a defective design from the outset, which was known about, albeit more has been learned.
Oh, I didn't read it that way. I read it the way I think Judge Cook read it in paragraph 13 of her decision. Page 44. In particular, the last sentence.
Okay, but it does go back to the point I was made. Why is it right to say that the problem with this building has existed right from the start? The question is whether the works that have been done from time to time were adequate to resolve the inherent structural defect, and the views have changed over time as to whether the works done were adequate, but the structural defect's been there from the start. It's the nature of these buildings, and you knew about that. You thought it's being remedied.
Hence the point being raised about it not being the antiquity of the building, but the architectural and engineering design of the structure.
If that's the reading of that part of the FTC decision, and I'm not pretending I don't see the force of what's been put out. This isn't an unfair point. If that's the reading of that part of the decision, then I'm going to have difficulties with the two leases with the carve-out. I can see that. But that doesn't affect the argument on the ones without the carve-out. In my submission, that's not what the FTT held. Judge Cook's paragraph 13 is the correct reading of this.
mean, I'm not sure I see the paragraph 13 really grapples with the point any more than paragraph 54 says the defect was there at the start and it still exists. It's inherent in the building. It's just that everybody thought until 2018 that the necessary works had been done, and because perhaps safety regs changed, or assessment as to what safety required had changed, in 2018 people took the view actually it probably isn't safe, that those remedial works probably weren't good enough, but the defect's been there right from the start.
Well,
That's very clear, a finding in 54. I mean, that defect was there at the start and still exists. I mean, nobody's criticising the local authority for acting on the basis of the professional advice, but the perception as to what is an adequate remedy for the inherent defect has changed.
might I take us back to the wording of the carve-out? Carve-out is only engaged if there are repairs as amount to the making good of a structural defect, other than structural defects notified or of which you do not become aware.
Well, at that first stage, the repairs are the making good of a structural defect, aren't they?
But they're not repairs. That's the reason why I haven't argued repair below. Because to be a repair, there has to be a deterioration in condition.
Do they really mean remedy a structural defect as opposed to repair? I mean, the concept of repairing a structural defect is a slightly odd one. If you're right about what repair means, I mean, if you've got a structural defect, you remedy it. No. Yes, no.
I agree with Mr. Bates on this point.
It's not open to me to suggest that below the Supreme Court, and even then I think I'd be laughed out of court, that repair means anything other than there is required to be a deterioration in condition. You can't repair something that hasn't changed.
Well, so what is the wording? Such repairs as amount to the making good of structural defects.
Well, once there's been some deterioration in condition. So this
Deterioration from what point?
So-
From the time when the building was built or from the date of the lease?
date of lease, I would say, because that's when there's a mutual arising of obligations will be from that date rather than from
Yes,
some
well, that's
earlier
what I'd have thought. But then if it refers to making good something which has already been notified, repairs can't be limited to things happening after the date of the lease, can they?
No, of course, they very much can. Most properties deteriorate in some way over time, even if it's just the passage of time. That's what repairing covenants catch.
Right. So you say the carve-out, save for such repairs as amount to the making good of structural defects. You say that only applies, carve-out only catches structural defects which have resulted from a deterioration to which you can then attach the word repair. And therefore inherent structural defects which have not deteriorated but which just are inherent don't fall within this carve-out.
Well, it might be better to describe them as latent defects, which don't have a manifestation in the form of cracks you can put your arm through or other physical consequences.
I'm conscious I'm slightly dodging my Lord's question, but let me try and answer it. It is not open to me to submit that a repair can be effected until there has been a deterioration in condition. Decisions of this court, and possibly even above, I can't remember them all. This is one of those things you drum into pupils doing this kind of work. There has to be a deterioration in condition. That is why, below, I tried to argue that maintain could mean something different, because I argued maintain is about achieving a functional state. That didn't get anywhere. I haven't renewed it to this court. It is no one's case that the building has changed in the sense of deteriorated in condition, which is, I think, the point all three of my lords have put to me. That being so, I struggle to see how what we are doing can be described as a repair. What you can have is works of repair which, when you carry them out in such a way as to remove an inherent or latent defect. So take one of the examples from the oldest of the cases. A building with no damp-proof course and water gets in. The building starts to fall into disrepair when the bricks start to crumble because they're changing in condition. You could repair them by just putting new dry bricks in. Or you could repair them by putting a damp-proof course in and allowing them to dry out. That would be works of repair to remedy an inherent defect based on the current state of the case law. I don't agree with that. It's post office, yes.
Quick taff's the one I like.
Yes. That would be perfectly permissible. That could be a legitimate repair. There may be other things to argue about. There's case law about when does repair lapse over into improvement, etc. But in principle, that is capable of being work of repair based on the settled state of the law. So it might be that if you've got a deterioration and you address it as a repair, you address it in such a way as to remedy the inherent or latent defect. But that isn't the same as saying I'm going out to remedy this before anything has happened.
Or as a consequence of the technical guidance as to what our tolerances for buildings of this kind in terms of normal and abnormal loads have changed.
Yes, my lord. So, in my respectful submission, the carve-out is a red herring to this case. Save that, what it does do is indicate that some works to deal with structural defects must fall within 5.5. Otherwise, you don't need it. So if I just try and pull this together into what amounts to ground one of the appeal, it goes in the following stages. Proposition 1, all of the leaseholders, irrespective of whether they have the carve-out or not, are required to pay towards the costs that we incur in, quote, carrying out their obligations under clause 5.5. What are my obligations under clause 5.5? Well, they include such works, installations, acts, matters, and things as may be necessary or advisable for the safety of the building. 5.5. On the evidence, there is no doubt this is necessary or desirable for the safety of the building. That is what the clear trend has been with all the material since 2017.
And you're not under any obligation to do it, though, until the service charge has been paid.
I want to be slightly careful about that. There's a decision of this court called Blue Storm Properties, which suggests that those words don't really mean what they commonly mean. Because it doesn't make any sense to have that situation in a multi-tenanted block. One person pays their service charge. You obviously can't repair just the bit around that person's flat.
So somebody somewhere has said that subject to and conditional upon doesn't actually mean subject to and conditional upon.
Right. It's always a question of construction of individual leases. It's two cases, one called Yorkbrook and one called Brewster of this case, both of the decisions of this court. And the answer is you look at the lease and decide what they mean. There might be leases that genuinely mean that. Lease of a house might be one. But in a multi-tenanted block, and it's certainly not my case, that this local authority is going to sit on its hands and say, no, 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 because you haven't paid us these £70,000 yet, we're not going to do these works. That's not a realistic way of reading this lease. So that's the answer to my Lord's question.
Yes, I was actually looking at a slightly different point of view. Actually, if the words did mean what they said, it rather suggests that works of this magnitude might not fall within it. Because if you say, well, your obligation to make the building safe under O is conditional upon being able to recover very large sums of money from the payers of the service charge, it rather suggests that that isn't a mechanism that parties could have envisaged, because they would have expected you to do it and then
Recover as best you can.
it's a species of an argument that sort of floats around in the FTT's, the Upper Tribunal's decision.
Yes. Again, but this is a point to make this clear. It's my submission that the cost of the work can't be relevant to what the clause means. In service charges, costs get taken into account at the reasonableness stage. That's how Parliament protects people against paying too much or paying for things that aren't needed. And we know that costs can't be the critical thing, because look at the opening words of 5.5a. Maintain and keep in good and substantial repair and condition. Repairs can be incredibly expensive. The idea that, suppose there'd been a terrible storm and all the roof slates are blown off, we're allowed to wait until everyone's paid us before we go and fix the roof. That's just not a realistic interpretation of this lease. We have to repair it, have to repair the building and then recover. So money doesn't tell you what's covered. What it will cost doesn't tell you what's within the scope of the works. The question on ground one, if I do it as the propositions I wanted to make good. Proposition one is that these leaseholders are obliged to pay towards the costs that we incur in carrying out our obligations under clause 5.5. Those obligations include, by virtue of 5.5o, doing or causing to be done all such works, installations, acts, matters and things as in our absolute discretion are necessary or advisable for the proper ... safety of the building.
Is that your proposition 2?
That's proposition 2.
Yeah.
And proposition 3 is the evidence is absolutely clear. This is for the safety of the building. In 2017, the government becomes aware of the problem with Southwark and tells every local authority to check their stock. We have a desktop survey which says do a full survey. The full survey says you've got normal and abnormal load problems. We then send out consultation notices in which we say we need to make your building safe. That's the only feasible reading of what's going on. Now that doesn't mean these leaseholders will all pay £60,000, £70,000, whatever it comes to. There may be a carve-out argument, there may be reasonableness arguments, but in principle we can charge something. As to how this court should approach that first part of Schedule 5 and then 5.5o, you'll forgive me for going to foundational authorities, but it's worth just flagging up Arnold and Britton in the Supreme Court. Each generation of Supreme Court judges with their own attempts to restate investors' compensation scheme. In the authorities at tab 5, so I can take you to authorities bundle tab 5. Arnold and Britton is a very unusual form of service charge dispute. It affects holiday chalets in Wales. And people are paying a service charge which was a fixed amount, but increasing at specified intervals on a fixed percentage basis and on a compound basis. So that, I think, remember from reading the High Court when this came out, in the last year of the leases, people are paying £1 million in service charges for these holiday chalets in the Gower. And the critical bit is Lord Newburger's judgment starting at 81, page 81, paragraphs 14, 15 and following. The reason Arnold in Britain is so important is not simply because it's a Supreme Court case, but because, of course, it's grappling with leases. And one of the things it does is do away with the idea that was developing there's some special rule about how you interpret leases. They're just contracts like any others. And that's why Lord Newburger starts at paragraph 15. When interpreting a written contract, the court is concerned to identify the intention of the parties by reference to what the reasonable person having all the background knowledge available to the parties would have understood them to mean. It does so by focusing on the relevant words in their documentary, factual and commercial context. The meaning has to be assessed in light of the natural and ordinary meaning of the clause, any other relevant provisions of the lease, the overall purpose of the clause in the lease, the facts and circumstances known or assumed by the parties, commercial common sense, but disregarding subjective evidence of parties' intentions. And then he develops some of those at 17 to 23. At 17, he makes the point that commercial common sense and surrounding circumstances can't be used to undermine the importance of the actual language. The exercise of interpreting a provision involves identifying what the parties meant through the eyes of a reasonable reader, and say perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. At 19, commercial common sense not to be invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously, is not a reason to depart from natural language. Paragraph 20. Whilst commercial common sense is a very important factor, the court should be slow to reject the natural meaning of the provision as correct, simply because it appears to be a very imprudent term. 21. One can take into account facts or circumstances which existed at the time the contract was made, which were known or readily available to both parties. And then 23. Reference was made in argument to service charge clauses being construed restrictively. I'm unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation. So closing down the idea that had been developing, that there's some special rule about service charges. He approves what Lord Justice Rick said in McHale at the end of paragraph 23, that the court shouldn't bring within general words something that doesn't belong there. But that's not an issue in that case, and isn't the issue in this case either. Safety is not a general word. So when one steps back and looks at the schedule, looks at clause 550, in my submission, this falls within the first part of that charging provision. These are works we are doing under 550. And to some extent, to a large extent, that's really the argument. I want to address a few points my learned friend Skeleton, picking up on things she adopts from Judge Cook's decision. Can I take you to First Skeleton, paragraph 15, which is in the core bundle at page 110. So these are the points my learned friend says that Judge Cook made, and she agrees with them. To take these in turn, 15.1, purpose of clause 550 is a form of future proofing, so as to pick up items that can't be specifically foreseen at the grant of the lease. I agree with that to an extent. That's not the only purpose of it. That clearly is a purpose, because no one can foresee on day one what the next 125 years will bring. But all of this, all of the points in paragraph 15, they're all in danger of being a distraction from the actual task. The actual task is to interpret the meaning of the words. 15.2, given its general nature, the answer to the question is whether the question to be answered is whether 550 was intended to cover an obligation to remedy structural defects. And I say no, that's the mistake Judge Cook made. If you frame the question that way, you've got the lease the wrong way around. You start with Schedule 5. You have to pay towards the things in clause 5.5. What does 5.5 include? It includes works of safety. Are these works of safety? Yes. I don't disagree with the second sentence that Arnold and Britton tells us to look at the facts and circumstances and commercial common sense. But commercial common sense, as Lord Newberger made clear, can't be used to undermine the meaning of the words. If these are works of safety, then they are works of safety, irrespective of the fact that on these facts, it gives rise to a potentially very significant financial liability.
And that's your answer to all of points 1 to 5, isn't it? You simply say that the question is whether these are works of safety, and if they are, they're within the clause, and if they're not, they're not.
I think it's
and that's the question which you say the judge ought to have asked.
I think it's probably my answer to ground 1 entirely, not just paragraph 15, yes. Very, very much so. But just picking up on some other points that impressed the judge and that my learned friend relies upon. Going to paragraph 18, a case that featured prominently below, a decision of this court called Dell. And we do need to spend a little bit of time on Dell, because it was so significant to the judge below and my learned friend places so much reliance upon it. It's in the authorities bundle at page 161. And if I can just ask the court to skim read H8 to H13, just for the background, because this was a very litigious building. So what we have in Dell is a company trying to recover a shortfall in assessed costs that it incurred in litigation against a neighbour from the service charge payers in its building. Interestingly, if you go to H7 in the head note, you'll see that their clause 4.4 was very similar to our clause 5.5. In particular, you'll see 4.4L, very similar to our 5.5.0. And what this court holds in Dell is that 4.4L isn't apt to include litigation costs of what was essentially a planning dispute with a neighbour. But the reason for that in my submission is that on the facts of their case, that was simply too far removed to be considered works of safety. So if we go to paragraph 36, the last sentence of paragraph 36 on page 171. It makes the point that the general reference in paragraph L to acts, matters and things follows references to works and installations which are clearly focused on the physical structure of the building. 37. The key operative words are the proper maintenance, safety, administration, or the proper maintenance, safety, amenity, administration of the building, respectively. In the context of a clause that clearly focuses on management and maintenance of the building itself, those words naturally refer to expenditure of that kind. Paragraph 38, the second sentence, concerns over structural integrity could involve safety issues, but the building was under no immediate threat of being rendered unsafe. So there's the difference with us. They were having a fight about planning. We're having a fight about a building that is, according to the expert evidence, in need of works of safety. And you see that clearly at the end of 38. In reality, the purpose of the expenditure was to stop Miss Hicks's proposed development, rather than to maintain 89 HP or keep it safe. It's just a very different case. Oh, sorry.
No.
It's not a case that establishes any particular rule of precedence or general application. It's an example of the correct approach, which is what do these words mean in this context? And do these works fall, or do these items, these costs, fall within the heading? And in Dell, the answer is no, because a planning dispute, wasn't sufficiently close to be said to be works of safety. But the factual differences with ours are stark, and in my submission, looking at Lady Justice Falk's judgment there, it seems to me that if she'd been confronted with our facts, she would have said it does fall within those clauses, because she's focusing on the need for there to be some actual imminent safety issue, which we know we have.
But what she's also focusing on is if you go back to paragraph 35, this is all to do with maintenance and management of the building, she says, and you have to read the reference to safety in that regard. She would say, I would suggest, in the same way as she was reading together. First of all, clause 5.50 comes at the end of a long series of things of, perhaps it would be wrong to say decreasing importance, but they are getting more granular. I mean, it comes after the entry phone system. So that's the first thing: is where is this placed? And then secondly, even within the clause, it's talking about proper management, maintenance, safety, amenity or administration. I mean, it's a word in the middle of 5 words, which Justice Falk would say, is essentially day-to-day matters. I mean, it might plainly include, for example, remedying some paving stones that somebody might trip over and hurt themselves, or perhaps the installation of some security on the site that was thought to be necessary to ensure safety at night or something like that. But it's in the context, why isn't it inapposite to include fundamental design defects of the whole building?
I'm not, again, 2 answers to that. The first is the danger of trying to take a decision about the meaning of a clause in one lease and apply it to other leases.
No, I'm not taking Dell and applying it. I'm saying that the same. It's not an unusual method of construction to look at the words in the company that they keep in the clause.
I would agree.
And in the company that this word safety keeps in that clause, given where the clause is in the document as a whole, what's your answer to the sort of suggestion that it's to do with safety matters of a more mundane operational nature rather than fundamental defect of the type that we're actually dealing with here?
Because respectfully, that is, again, to start trying to put glosses on the word safety.
No, you always have to look at words in their context. You don't, I think some great lord once said, you don't just take the word and take it out to a laboratory and look at it under a microscope. You've got to look at it where it appears in the clause, and nobody's ever changed that method of interpretation.
No, I accept that. To which I would say, it seems to me, starting first with legislative faults and then answering more generally, that's why I have paragraph 38, second sentence. Concerns over structural integrity could involve safety issues, but the building was under no immediate threat of being rendered unsafe. She's right, respectfully. She's right in that case, and she's right more generally, because what she's doing is she's asking herself, what is needed to engage a covenant in relation to safety? What the threat to the structure would do? The suggestion that it's all, that there's more of a day-to-day focus, I'd respectfully push back on. The opening words of 5.5a are self-evidently not going to be day-to-day. Repairs, the very nature of them is we shouldn't be doing them day-to-day. You want to do them on a cyclical basis.
I understand you've made that point about that the absolute cost is not a driver of interpretation. I mean, that's a different point, I think, in respect. I mean, this clause, 5.5 as a whole, you'd say plainly can catch some pretty large items of expenditure.
Yes.
So yeah, I understand that point. But where you look at, where you get down to 5.5.0 and look at that word safety, which is the only word you actually rely upon, but in the context, is it not dealing with safety matters of a more, as I say, more mundane nature?
The answer I give, my lord, is go back to the opening words of 5.5.0, without prejudice to the foregoing. So the author of the clause has taken the point my lord put to me, that we've got some quite detailed, specific examples. He's nonetheless aware that he hasn't caught everything relating to proper management, maintenance, safety, amenity, or administration. And so he said in there that without prejudice to the detailed and increasingly, I think Lord said granular, I think I'd agree with that, increasingly granular list, the draftsman has recognised that there will still be things that he couldn't foresee that relate to the proper management, maintenance, safety, amenity, or administration of the building, and he said landlords must do them.
Yeah, but it.
Well, essentially, you say, do you, that the drafter is aware that he may not have caught all safety points, so he sweeps them up, however big or small they may be.
Yes, I'd be slightly cautious about using the word sweeper clause, because in this area of law, that's one of those phrases that's thrown around slightly pejoratively there at the end. I just draw my lord's attention to what the Deputy President of the Upper Tribunal said in the asset hold case, which is behind tab 6, page 131. It's paragraphs 58 and 59. In 58, culminating in the last sentence, the point the Deputy President makes is that language can be clear even if it's not specific. It's the danger of just characterising it as a sweeper clause and then saying, well, sweeper clauses get interpreted restrictively. We ask ourselves, what does the word mean? Or what do the words mean in their context? Safety is a clear word. It may not be specific. It hasn't identified how you make it safe, but it's not an ambiguous or unclear word. We shouldn't strive in leases to find a lack of clarity. And respectfully, in my submission, that's what Judge Cook has done, and it's the route my learned friend invites you to go down. I mean, in asset hold, if you just go back to page 129, italicized words at the end of page 129, paragraph 6, schedule 1. Clause, all works, installations, acts, matters and things in the reasonable discretion of the landlord may be considered necessary or desirable for the proper maintenance, safety, amenity and administration of the development. That was held, paragraph 59, to be apt to include litigation with a neighbour about a party wall. You didn't need to have, as some of the authorities have suggested, express references to lawyers to get legal costs. If you could show that the work, as they could show in this case, that the party wall dispute was about safety, it was about preventing them undermining a party wall, then why didn't it fall within the clause? It all comes back to the same singular point. What do these words mean? And the answer to that question is in the propositions I put to my lords earlier. Firstly, are they within clause 550? Because if yes, you have to pay for them. And the answer is yes, because they are works of safety.
Right. Is that ground one?
That is ground one. I have one eye on the time, so I need to make more progress in order to keep myself to the short adjournment. Turning then to ground 2. And this is looking at pages 43 and 44 of the supplemental bundle, terms of the lease. So the intellectual premise for ground 2 is that I'm not acting under clause 5.5, because that's ground 1. If I'm not acting under clause 5.5, then as we looked at earlier, I must be acting under the implied covenant to remedy structural defects. The total expenditure definition in pages 43 and 44 has 2 elements to it. Means the total expenditure incurred by the lessors in any accounting period in carrying out their obligations under clause 5.5 of this lease, ... for the proviso, and any other costs and expenses.
No, it has 3 bits. Why do you miss out the words preceding that? And also of ensuring against the making good of structural defects. I mean, that's the other thing, isn't it? I mean,
that's in the proviso.
Is it?
Yes. So Judge Cook sets this out very, very nicely in her judgment. If we go to the Upper Tribunal decision in the core bundle, page 45, paragraph 17. You see there the italicized words of the proviso that are in the 2 leases, and they stop.
I know, but she doesn't explain why that's the case. I mean, if the premise for your argument here is that there is a statutory obligation upon the landlord to make good. Sorry, I haven't got the wording in front of me.
Schedule 6, paragraph 14, to make good structural defects.
To make good structural defects. So there's an obligation imposed by statute on the landlord to make good structural defects. Why don't you read this? I mean, those words envisage that the landlord would be insuring against the cost of that liability on it. And if you're right, it can charge the tenants with the insurance costs, but it can't claim that the actual costs fall within the next phrase, any other costs and expenses reasonably and properly incurred. And if all you've got against it is that the judge at page 45 let the italics run on to include that phrase, I'd be very keen to know what's the underlying rationale for that.
I think there may be a confusion here that perhaps I've contributed to. In all but two of the leases, those italicised words in paragraph 17 just don't exist.
Right.
So in two of the leases, so in all but two of the leases, the covenant is total expenditure means the total expenditure incurred by the lessors in any accounting period in carrying out their obligations under 5.5 of this lease, less sums expended from the money set aside under 5.5p of this lease, and any other costs and expenses reasonably and properly incurred in connection with the building.
But as it happens, we're looking at this lease, and I'm not sure we can interpret this lease by reference to some other lease that doesn't include those words. So I'm just at the moment focusing on this lease we're actually looking at.
Right.
What's the answer to the proposition that the costs of insuring against the landlord's implied obligation would be recoverable, but not the actual costs of doing it?
So can I swap these round, because this is in danger of becoming a tail wagging dog situation in my submission. It's only two of these leases that have this italicized words. Two of them say nothing at all about all but two of them say nothing at all about insuring for structural defects. So start with the most numerous category of leases, which is those who ignore all of those italicized words.
Okay, well, give us can you give me an example
Yes,
of
of
those?
course. Let's go to so let's go to 997, right at the end of the supplemental bundle, which is the lease of 46 Brewster House.
Seven.
997, yes.
Where does it start?
Fifth schedule, the service charge.
Sorry, is this the lease that starts at 981?
So it starts at 981.
Okay, but okay, this. I'm not going to be able to interpret a lease that was entered into in 1989 by reference to a lease that was in 2003.
And I'm not asking my lord to. This is clearly my fault. Not having said that clearly enough. We've just used that lease that we've been looking at the early part of this bundle, simply because it was first in time and first in the bundle.
Yeah.
It's an example. It's got one other leases in the same form.
Okay.
The majority of them are in this form.
Okay, but just speaking for myself, I mean, I appreciate you may have a different argument on a subsequent lease which doesn't include those words, but just using this lease, which we have been looking at, admittedly it's in a minority, why don't you read those words and also insuring against the making good of structural defects to signify that it would be the landlord that would be able to pass on to the tenants through the service charge the insurance premiums of insuring against its personal liability, but not claim that the actual costs of carrying out the works were within the next phrase and any other costs and expenses reasonably and properly incurred, because there's already been specific reference to how the landlord, what the landlord can pass on in relation to the making good of structural defects. It's the insurance premium. It's not the actual cost of doing it.
So in that respect, for those two leases, the things that can be insured against in my submission, the making good of the structural defects, to which the proviso applies. It's not a freestanding right to let you, for the next 125 years, to make these leaseholders pay for an insurance policy in respect of any structural defect whenever it might arise. What the proviso is doing is saying that for those two leaseholders who've got the carve out, you don't have to pay for structural defects unless we've told you about them in Schedule 6, or they arise 5 years and 1 day after we sold you the lease, but we can make you pay for insurance in respect of these things. so that there won't be unfunded obligations. That's how, that's how we read that covenant. It's not saying that a leaseholder with that carve out can be required for 125 years to keep paying towards an insurance policy for structural defects outside the scope of the carve out. What the carve out is doing is finding someone else to pay for the things we can't charge the leaseholder for. And rather than the leaseholder paying the enormous cost of the work, they pay the much more modest cost of the insurance premium. That's my answer to my Lord's question. But for all but 2 of the leases, it doesn't matter.
Okay, but just with this clause, sorry, it may be that I'm just being slow. The statutory background is that the landlord has an obligation to carry out the making good of structural defects. They can choose to insure against that or not.
Yeah.
That's up to them.
Yeah. Agreed.
Let's assume they don't insure against it. You are saying, as I understand it, that we read this as that if they don't bother to insure and have to make good structural defects, they can pass the cost of doing that against the tenants under the words "and any other costs and expenses reasonably and properly incurred in connection with the building."
If it's not caught by the carve out, yes. For the leases that haven't got the carve out, this is a complete red herring in my submission. For the leases that haven't got the carve out, they pay for the obligations under clause 5.5 and any other costs and expenses reasonably and properly incurred. So if it's not a 5.5 cost, they pay for it as long as it's reasonably and properly incurred.
Right.
For the 2 with... sorry, my lord.
Sorry, but I'm just looking at this lease, just focusing on this lease. At the time that you would enter into it, if the landlord doesn't choose to insure, you say it can pass the cost of doing the works onto the tenants in any event under those words.
So under the lease with the carve out, the insurance provision is designed to enable the landlord to recover the costs of an insurance premium in respect of the works for which it cannot charge because of the carve out. If the carve out isn't engaged, e.g. because it's in Schedule 6, or because the defect arose 5 years and 1 day later, then to charge for it, I've either got to go for 550 or I've got to come within the other costs and expenses reasonably incurred. I see much bafflement, which is never a good sign. I think the difference between the answer I'm giving and my Lord's question, I think my Lord's question is putting to me that the insurance provision in the carve-out is broader than I'm submitting it is. I think my Lord is suggesting...
And cast some light upon the breadth or otherwise of the words that follow it and any other costs and expenses reasonably and properly incurred.
If you could insure for a cost and had chosen not to,
why would you bother to insure if you could just pass the cost on to the tenant?
well,
Why waste the time insuring?
because of how statutory reasonableness works. It's got to be reasonable to incur the cost. If there was some way of avoiding incurring the cost, it won't be payable at all, or only the premium value might be payable.
I mean, one problem with this is we don't have any findings as to what insurance was available or what it would have cost.
No.
So it's rather hard to know whether a landlord would have acted unreasonably if he had failed to take out the insurance which was available on the market. It's just a sort of black hole.
Yes. But on the interpretation point, it is implementation. I think the difference between what's put to me and the answers I'm giving, my submission is that the power to insure is tied to the structural defects dealt with in the carve-out. It's not a general power to insure generally for structural defects. If I'm wrong about that, then I do see the force of what my lord's putting to me. Because that would mean that for those leases, there was a 125-year power to charge insurance. And I agree, it's not controversial to say the existence of such a power must inform the subsequent words. I have no difficulty with that. But the answer, as I say, is twofold. For those leases that do have the carve-out, that's not what we say it means. We say it's insurance in respect of the things that are caught by the carve-out. And most of the leases don't have the carve-out at all. Most of the leases go from your obligations under clause 5.5 as charging route 1 and any other costs and expenses reasonably incurred. For those leases, what in fact I am doing is work to comply with my statutory covenant, it must be a cost reasonably and properly incurred. And so it would be chargeable under that part of the charging covenant. I hope that answered the question, even if not entirely satisfactorily. I think at least I understand the points being put to me. I'll see if I can think of a better answer over the short adjournment. But that is ground 2 very shortly. I have thus far lost at both stages on the argument that in principle it's a second right to charge. That is the argument in a nutshell here, is actually when it says in the lease, let me get it, and any other costs or expenses reasonably properly incurred, it means what it says. It means any other cost and expense, i.e. not one within 5.5. Let me just deal then very briefly in my last 5 minutes with the right to buy position. The argument as it's put in writing is largely to do with the policy of the right to buy. And if you can go to tab 8 of the authorities bundle, a decision of this court in City of London and Leaseholders of Great Arthur House. Paragraph 50 in Lord James Lewison's judgment.
Can I have a page, please?
At 159, sorry, my lord.
Yeah.
And Lord Justice Lewison makes the point, which is plainly not controversial, that the purpose of the legislation was to encourage home ownership by council tenants, often people of modest means, which was achieved not only by giving them the right to buy at all, but allowing them to buy at a substantial discount from market value. And then towards the end of that paragraph, he says, it's by no means surprising Parliament gave a measure of consumer protection to people to whom the right to buy was given by partially insulating them from a liability to rectify the costs of structural defects in the property in question. And that's the policy point my friend relies upon. She says you've got to interpret this lease against the policy background of the right to buy. I have 2 answers to that. The first is, that's not the only policy of the right to buy. That's certainly one of the policies. But if we look at a decision called London Borough of Brent and Hamilton, which is behind tab 3, a decision of the Lands Tribunal as it was for the Upper Tribunal, and the then President George Bartlett, QC, grappling again with policy arguments in relation to the right to buy. If we just go to paragraph 12 on page 45, it's the final sentence. I'll read it all out. It seems improbable that a housing authority forced in 1986 to sell part of its housing stock at a substantial discount and at a nominal ground rent would have chosen to subsidise the purchasing tenant by including in the lease a provision that made her liable for part only of the council's costs in performing its covenant under the lease. That's the other aspect of the right to buy that gets overlooked. It's forced sale at sub-market value.
Why is it at sub-market value?
Because of the parliamentary intent, I'm happy to accept that. Parliament took a view it should be at sub-market value. That doesn't mean...
Because what, people who are likely to be buying it won't be able to afford full market value?
There's a variety of different policy reasons that have been given by different politicians from time to time. But yes, bearing in mind you would have been, you had to be a secure tenant. The reality is, even by the early 1980s, we were beginning to see the decline of the mixed income estates that Bevan and others wanted at the beginning of council housing. We were beginning to see council housing largely occupied by people of lower socioeconomic means. So you did need to have it at sub-market value. And as we know from anyone who's got any understanding of the history, the aim of the then Conservative government was to create property owning democracy, and that was the point of it, to sell it off. So that's a different question from, was there intended to be a 125-year subsidy? So you can't simply take, as Lord Justice Lewison did in my submission, the broad policy that Parliament wanted to encourage home ownership and say, well, that must mean that they also intended to provide ongoing subsidies. The subsidy was the discount, not ongoing 125-year restrictions on what you could charge for. So the policy isn't quite as simple as the case my own friend goes to. But secondly, if the court will indulge me, I'll finish on right to buy, and then I can probably stop.
Yeah, how long do you need?
5 minutes.
I've got to go and see Jonathan Baker, but I mean, I can do.
No, we'll stop now, where you can have your 5 minutes at 2 o'clock,
Thank you very much.
so long as it doesn't expand into 10 or 15.
I'll tell my own friend to kick me if I go too long.
What, raise a table?